Welcome once again to Lehto's Law. Here's Steve Lehto.
I told you a while back about a case out of Michigan involving tire chalk. The police chalking your tires to see if you've overstayed your welcome at a parking meter in a downtown area. And there's a case out of Michigan on that went up to the federal court on appeal. And the Court of Appeals actually said that the tire chalking was unconstitutional. It's a violation of the Fourth Amendment. So interestingly, several people said, Steve, check this out. Out of the Ninth Circuit, a case out of San Diego has ruled the exact opposite way. So we have what we call a split in the circuits. Sixth Circuit says yes. Ninth Circuit says no, with respect to that being a violation of your constitutional rights. So is there a solution for this? It's possible that the two courts could just keep going and no one will appeal this to the Supreme Court. Or it could be that someone takes us up and says, hey, we've got a split. We need SCOTUS to decide this. And then we would see what happens. But from 10news.com, City News Service wrote it, Ninth Circuit Court of Appeals upholds chalking tires in the city of San Diego. The Ninth Circuit has upheld the long-standing practice of chalking tires to enforce time limits in parking spaces on city streets. That's according to the San Diego City Attorney's Office. Now, the decision was a 2-1. It was a 2-1, meaning that one judge said, I disagree, but you lose. The panel voted that the dusting of chalk on a tire does not constitute an illegal search under the Fourth Amendment. I assume dusting there is a reference to how much chalk and not the manner in which it's put on. The plaintiffs in the case argued in their 2019 class action lawsuit against the city and its police department that chalking tires is an unconstitutional intrusion on owners of legally parked vehicles. Because remember, you park your car, you pay the money in the meter, the police officer comes by, or the meter person, and chalks your tire while you are still current on the meter. Because if you're not current on the meter, they don't chalk your tire, they just give you a ticket. So they're chalking the tires of people who are legally parked. Now, some of them overstay, but then they get a ticket. So a judge granted the city's motion for summary judgment early last year, and the plaintiffs appealed. Summary judgment, by the way, means that a judge or a court looked at a case and said there's nothing to try here. Based on these facts, one side is just entitled to win. There can be a bunch of different bases for that, but that's one here where they said, look, assuming these facts are true, there's nothing to try here. So that's what the judge was saying. So in the majority opinion on appeal, the judge wrote that chalking tires falls under the Fourth Amendment's administrative search exception, writing that the practice's intrusion on personal liberty is de minimis at most, and stated chalking tires involves no detention of a person or property, does not damage property or add anything permanent to it, and the search does not create substantial anxiety, as some searches may. De minimis, of course, is Latin for meaning basically next to nothing, as little as it can get, de minimis. And so it's true that if they chalk your tire lightly, just lightly, and you don't even notice it, then that's about as de minimis as it gets. Now, I've had people point out, and they say, Steve, I just, hypothetically, detailed my car. I just detailed my car, and I parked it, and I walked in to get some coffee, walked back out, and some knucklehead's taken a piece of chalk and went on my tire. I don't like that. And I can see where that might be more than de minimis, but City Attorney Mara Elliott praised the ruling in a statement saying San Diego has chalked tires as an effective, cost-efficient, accurate means of parking enforcement for nearly 100 years. The court was correct in determining that chalking a tire does not represent an illegal search and in rejecting the plaintiff's unsupported revisionist account of Fourth Amendment doctrine. She's apparently unaware of the Sixth Circuit Court of Appeals opinion that says that she's wrong. And I love that when somebody goes insane going, what a ridiculous argument. And another court's held that ridiculous argument is actually good. In a dissenting opinion, a judge wrote, the city's practice violates the constitutional rights of its citizens by allowing for warrantless searches. That judge said the chalking policy constitutes a search under the Fourth Amendment and one that is conducted without evidence of wrongdoing, making them, by definition, unconstitutional. Said the searches don't fall under the administrative search exception because it did not address a pressing and exceptional government interest, such as conducting sobriety checkpoints to curb drunk driving. And that's one of the other questions people had. When you look at something the government's doing that's intrusive, you always have to ask, is there a way they could do it that's less intrusive? Is there some way they could check to see how long you've been at that meter without chalking your tire? And people point out, for instance, they could chalk the ground. They could actually come by and draw a chalk mark on the ground that indicates something. Or they could photograph the cars. And there's a bunch of other stuff they can do nowadays, but it is no doubt true that law enforcement, traffic enforcement, and almost any other government function would be more efficient, more convenient if officers could skirt the Fourth Amendment. But inconvenience is the constitutional design. So they can't say merely for convenience we want to violate the Fourth Amendment, because that would always be their excuse then. I pointed out earlier that there's a case out of mid-Michigan, up in this area, that the Sixth Circuit ruled was a violation of constitutional rights of the people whose tires were chalked. And that case involved 5 years of litigation, 2 appeals, and the Sixth Circuit finally came to the conclusion that it was, in fact, a violation, but a small one. A small one. They didn't say it was the crime of the century. And in fact, the judge in that case, when it wrapped up, awarded the victims, people who had this done to them, $1 apiece in nominal damages. And the interesting thing is that the tickets that people were complaining about were $15 if you paid it on time and $30 if you paid it late. So you may have paid a $15 or $30 ticket and gotten $1 for your trouble. And a lot of people just assumed, well, if I got a ticket that I shouldn't have gotten because they shouldn't have chalked my tire, I should get a full refund. The judge said, no. We're going to say those tickets are still kind of good, but that for this de minimis intrusion on your life, we'll give you $1 each. And so the attorneys in that case took the position it was still a win because the city had to change how they were doing this going forward. So right now, you've got the Sixth Circuit that says it is a constitutional violation. Sixth Circuit covers Michigan, Ohio, Kentucky, and Tennessee, I think. And then, of course, the Ninth Circuit is out west. Got that. So right now, you've got 2 circuits that are diametrically opposed. One says yes, one says no. And now, other circuits, when facing this question, are not bound by those circuits. And of course, let's suppose that you are in another circuit making this argument. If you're in favor of tire chalking, you point the Ninth and go, look at those geniuses over there. What brilliant judges they have. And if you're against it, you point to the Sixth and go, look at those geniuses over there. What brilliant justices they have. Look at this sound reasoning. Follow their example. You're not bound by it, but you can be guided by it. And of course, the other side says about the other. So the only way to resolve this would be if someone takes a case like this up to the Supreme Court. So the plaintiffs in the case in San Francisco could still do that, I believe. We could see what happens there. And one of the reasons that you can argue as to why your case should be heard by the Supreme Court is we've got confusion out there. We've got splits in the circuits. We got one circuit saying yes, one circuit saying no. Therefore, the only people who can straighten us out are the Supreme Court. But as we pointed out before, the Supreme Court does not take the vast majority of cases offered to them. And you can never guess what cases they're going to like or not like. And so some people would say, well, Steve, an obvious split between the circuits is something they ought to hear. And I'd say yes to that until you realize, yes, but we're arguing about tire chalk. And they might look at that and go, chalking tires? We have more important stuff to talk about. So meanwhile, somebody else who's on death row files a last-minute appeal or they get executed in 24 hours. Yeah, they're going to actually look at that first because it's a little more pressing. So we'll see what happens, but it's a fascinating case, and I can see both sides. I can. And I'm fascinated now to find out if the Supreme Court will hear this, and if so, how they'll rule. Scott and Frank both sent it. Thanks a lot. But 10news.com reports Ninth Circuit Court of Appeals upholds chalking tires in city of San Diego. Questions, comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Where there's a will, I want to be in it.